Okay, hello, welcome. I can see people flooding in, which is really exciting. Nothing worse than talking to an empty room. So welcome, welcome, welcome. Lovely to see you all, if albeit virtually. Some of you will know me, some of you will have attended some of these webinars before. Some of you will be clients, some of you will be business owners, some of you are accountants and payroll people. So welcome. I will aim to get started fairly promptly. I have a lot to get through and I want to leave as much time today as possible for questions and answers. I think that this topic, certainly when I've been speaking to people, has raised a lot of questions and therefore although I'd like to think I'm going to do a good job with the presentation, I would like the opportunity to take your questions as well. Please don't use the chat facility. If you've got questions to ask, then please pop them into the Q&A panel. You should see that Q&A at the bottom of your page. Any questions as we go through, then please drop them in there and I will pause and try and answer some of those both during the presentation and at the end of the presentation. We've got a nice number of people booked on today. We've got over 30, or we've got nearly 40 people booked on for today's webinar. The slides will be available after today. And I will also send out the recording of the webinar as soon as it's available. And I'm going to try and get that captioned as well. So there'll be lots of contact with you over the next couple of days. I've also got an offer for you at the end of today, if that's something that's of interest. 95% of today is going to be based on the new regulations around annual leave. I will just touch on the IR35 announcement that was made by Kwasi Kwarteng on Friday of last week. Just from an HR perspective, I'm not going to try and decipher the tax legislation or the tax implications of that, but from an HR perspective, I will just cover that in one of the slides at the very end of today's presentation. So again, thank you very much for joining us. I am going to start shortly. The Q&A box is open, so if you have any questions, please do pop them into there. And let's get started. So let's talk about the way it was. I think a lot of people had really understood the way in which holiday was calculated in the past. The need for holiday calculations actually came from the Working Time Directive. So we've been working and living with them for many, many years now. And they haven't really changed substantially since they were introduced. The real change was actually down at the bottom here, this last bullet point. Some less scrupulous employers were forcing employees to to work all of the time and not to take any holiday at all. And therefore, up until these changes, which we're going to talk about today, the most recent change was just to say, well, actually, you shouldn't be paying people for their leave. They have to actually take it. Okay, so up until today, or up until July, the ruling the rule was that employees accrued holiday time at a rate of at least 12.707%. Now, what many employers did is they increased that percentage if they gave more holiday time to their full-time staff. So that 12.07% is based on the minimum of 28 working days, 5.6 weeks. If a full-time member of staff has their 20 days plus their 8 public and bank holidays, then they would have been entitled to 12.07% holiday. that should have been accrued and then paid when people took the holiday. And in a few cases, with a few exceptions, then people could be paid for their holiday, but there still needed to be a communication as to when they were actually taking it. And if you did put it onto people's pay slips and pay it as they earn it, then you had to show it as a separate line. That was the percentage method. That was the percentage method. We're now no longer allowed to use that percentage method. It's all change. So let's look at why the change, first of all. So the case law, and I hate case law, and I never normally quote case law, but you are very welcome to go back and look at this. It's called Harper Trust versus Brazel. Harper Trust is a school. It's a trust that has schools employed. Brazel was I can never say it, peripatetic teacher. So someone who came in and taught music. And they taught music to as many children who were in school at the time, and they were paid for the sessions that they taught. So if they've got a whole year group out on a field trip and maybe 10 kids didn't turn up for their lessons in 1 week because they were away on a residential or something, then that music teacher worked 10 hours less than they would have done normally. And what that meant on the percentage method was that they got paid less holiday, or they accrued less holiday. And Brazel in 2017 took a case against the employer, the Harper Trust, to say that actually they were being underpaid holiday. And the case was supported by the trade union. And the trade union were very heavily involved in this case. Whether they continued to support the case all the way through is actually up for debate, but they were involved. In 2017, having gone to the Employment Tribunal and the Employment Appeals Tribunal, there was a ruling which said that the percentage formula was wrong and that employers now had to pay based on 5.6 weeks. The Harper Trust said this is absolute madness, and they took it to the Supreme Court. It's taken all this time to then get to the Supreme Court. A few organisations did make changes back in 2019, but the majority didn't, because the ruling felt so wrong that they were absolutely convinced that the Supreme Court were going to overturn it. However, the Supreme Court didn't, and now all organisations, and I mean all organisations, are required to comply with the decision of the Supreme Court, and the average weekly pay now needs to be paid to employees who take their holiday. So who's affected by this? Well, the first thing is they need to be on payroll. This obviously affects term time only staff, because that's where this started. So it affects everybody who is not working 52 weeks of the year or 44, 46 weeks of the year plus holiday, depending on how you work it out. But if they're not a full year employee, then this affects the way in which people are paid for their holiday. It applies to people on term time only contracts. It applies to people on 0 hours contracts. So if you are employed on an ad hoc basis, you're on payroll, and the employer can call you in whenever they want to work some shifts or offer you the shifts, which you then have the right to decline or not if your contract's set up properly. Those people on those 0 hours contracts are affected by this change. Anybody who's on annual hours contracts is also affected by this change, although not as much. People like bank staff and agency workers who are called in and only work when required are also affected by this. Okay, so I think back to when I was at school. If a teacher was off, then we had cover teachers that knew the school, knew the students, would come in and would just work a few hours or a week to cover maybe a sickness period or something like that, but they were on payroll and they could very easily be brought in at any time in order to cover the work. So those are the people who are affected. Now, we think that it's going to be specific industries that are affected more than others, but those are the people who are affected. Who's not affected? So anybody who's on a full-time contract, if they're working Monday to Friday, 9 to 5, for example, or Monday to Saturday, 9 till 6, or whatever it is, those people aren't affected. They're still entitled to annual leave in the same way as they have been. Also, part-time employees with fixed weekly hours who work full year. So if somebody does 3 days a week, 52 weeks of the year, they're not affected by this because 5.6 weeks is still 5.6 of their weeks. Contractors aren't affected by this, and nor are freelancers, as long as they are genuinely freelancers and contractors. As I said, I will touch very slightly on IR35 when we get to the end of today, but generally, if you've got fixed working patterns every single week of the year, then you're not affected by this. So which industries do we think are going to be most affected? Well, we know that in retail, hospitality, social care and education specifically, people tend to have 0 hours contracts. You know, if it's a restaurant, they may pick up shifts here and there. They may be offered shifts here and there. Some of them may have set routines, but they may swap those routines. They may not come in and do 2 nights. They may come in and do 2 shorter days and then 3 nights or whatever it is. But where there is not fixed hours, then those industries are going to be more heavily impacted. Cleaners, security guards, again, if they're on full-time contracts and they're contracted for 40 hours a week, this isn't going to affect them. If their hours change and they do, I don't know, 4 days on, 4 days off, 4 days on, 4 days off, their weekly pay is going to change on a weekly basis. 4 days on, 4 days off is an 8-day pattern, and therefore in any 7-day week, the number of days they're actually working is going to change. So they will be affected by this ruling. And quite a lot of charities don't use staff the whole time. They bring them in for projects during the year. So they're on payroll, but they come in and deliver projects on an ad hoc basis for part of the year. Those guys are also going to be affected. So, leave entitlement. The legislation, when it was written, said that employees are entitled to 5.6 weeks of leave. Okay, and the percentage method says that's fine. If you work a full year, you get your 5.6 weeks. But if perhaps you only work 36 weeks of the year, then you're only working 70% of the year. Therefore, you get 70% of your 5.6 weeks. So you, instead of getting 5.6 weeks of leave, you would only be paid for your 3.88 weeks of leave. But you're only working 36 weeks in the year. So if you take your 36 and you add your 3.88, you're at 39.88. So you're getting more time off, but you're not getting the pay for it. And what this legislation is saying is that actually, what this Supreme Court ruling is saying is that there was no provision in the legislation to reduce the 5.6 weeks. And therefore, regardless of how many weeks in the year an employee works, they are still entitled to 5.6 weeks of leave. For some organisations, that's going to be 28 days. But if the organisation works, for example, a 6-day week, then that 5.6 weeks is 5.6 of their working weeks. I'm going to stop there and ask if anyone's got any questions. If there are any questions, please pop it into the Q&A box. Okay, I'm not seeing anything come up, so I'm going to take that as good sign. So this is where the fun begins. We know that they're entitled. Sarah, I'll come back to it. Thank you. We know that they're entitled to 5.6 weeks of pay, of leave. But how do we work out how much they need to be paid for that time? Okay, so it's 5.6 weeks. That could be 28 days, but it could vary depending on what a week is worth within your business. So the first concept that we need to get our heads around is the reference period. And in order to work out an average weekly pay, we've got a 52-week reference period. Now, what we can't just do is go back 52 weeks and work out the average. So I don't know, say it's £10,000 earned. We can't take £10,000 and divide it by 52, because in some of those weeks, the employee will not have earned anything at all. And if they haven't earned anything in that particular week, we have to discount that week and go back to week 53. And if there is another week where they haven't earned anything, we discount that week and go and include week 54. And we're constantly going back in time up to 104 weeks, so up to 2 years. We're constantly going back in time until we've got 52 weeks in which the employee was paid. That becomes their reference period. Okay. Now that reference period has to be recalculated each time the employee takes leave. So if somebody books a day off, in order to figure out how much you're going to pay them for that day, you need to look at the reference period, the 52 weeks in which they've had pay ahead of the day that they're going to have off. Even if they're paid monthly, the pay needs to be calculated on a weekly basis. So even if you always pay at the end of every month, you need to calculate the pay on a weekly basis because of that rule about needing 52 weeks. So you can't just clump 4 weeks together and say this is the pay for that period. You have to know on a week-by-week basis whether or not the person has received pay. What is pay? Well, pay is obviously salary. That's the easy bit. It can also include commission. It can also include any bonus payments that were paid and any holiday pay. So in a week where somebody has taken leave and they've been paid holiday pay for that leave, that figure then becomes part of their 52-week reference period. Even if it was just a day and the rest of the week was paid. Sick pay, if somebody goes off sick, then you need to ignore the fact that it was sick pay and work out what they would have been paid if they'd have been receiving full pay for that week. And that's the figure that gets used for that particular week. Now, I think that that one's going to get challenged at some point. But at the moment, the way that we've read it and the way that the ruling has been interpreted, sick pay gets treated as full pay for the purposes of working out the average weekly pay. So just to go back over that, you've got 5.6 weeks that have to be taken and paid for. and it has to be done without proratering. If you give 28 days to everybody else in the company, based on working Monday to Friday, 9 to 5, then it's 5.6 weeks of 20, which equates to 28 days. But if, for example, somebody is working 6 days a week, then it's 5.6 of their weeks. Okay, I hope that makes sense. Let's go back to the next one. So we're looking at our reference period where you ignore any weeks without pay. And you have to have 52 weeks. And you can go back, you need to go back a maximum of 104 weeks. If the person hasn't got 52 weeks worth of pay in that 104-week period, either because they're a new starter or just because they haven't done that much work, then you just take the number of weeks that you've got. Okay, but in an ideal world, you're looking for 52 weeks out of a 104-week period in the time immediately preceding the time that the leave is taken. You need to put everything into a weekly figure. You need to include everything that's been paid, and sick pay needs to be treated as full pay. I hope you are still with me. So really good question, Sarah. So furlough will come into that period, but use the figure that they were paid. So whatever you paid them for that week, then use that figure. And if that included government funding and all the rest of it, use that figure, and the same with flexi furlough. I haven't seen anything that makes any provisions separately for that. It is just talking about the leave that they've taken. I might have a look at that and come back to that one, but that's my understanding for the way in which furlough is used, because you're looking at what has actually been paid. So every time somebody takes leave, you need to recalculate the reference period and calculate then what the average weekly pay is in that reference period directly before the leave. So if they're taking 2 weeks leave, or whether they're taking 1 day's leave, you work out the reference period in the 52 weeks directly before the leave. If they're taking 1 day, we have made the assumption that you're dividing the average weekly pay by the number of days that they would normally work if they were working full time. There's not been enough clarity on that at the moment, but everything that the HR community and some of the solicitors are saying is that you take that average weekly pay and divide it by 5 or divide it by 6, depending on what the normal hours are. And you must do it every single time. You can't use the figure that you used before. You need to calculate it fresh each time. So let's have a look at an example. So this example, and I've cheated a little bit, so please forgive me, and we will talk about starters and leavers in a minute. This person has been with the company for 3 months and they earn £10 an hour. So in week 1, they worked 10 hours and therefore they got 100 weeks pay, £100 pay. In week 2, they did 40 hours and therefore their pay was £400. But the following week, they did no hours. So you literally ignore that week from your calculations. Okay. And what we end up here, by the time that we've worked through the table, is that the total salary earned was £1,590. There were 9 weeks that were worked, and therefore the average weekly pay, so if someone were to take holiday in week 14 for the week, they would be paid £176.67 for that holiday, for that week that they were taking. Okay, I hope that makes sense. And the slide's not gone forward. There we go. So starters and leavers. I said I would touch on the starters and leavers. We are allowed to prorata the number of weeks of leave for the starters and the leavers. So if somebody starts 3 months into the year, then they will get 9/12 of their 5.6 weeks. You still calculate the pay in the same way as we've just described, but their actual entitlement is to 3/4 of their 5.6 weeks. And the same for a leaver. So if somebody only works for 6 months of the year, then instead of the 5.6 weeks, it would be 50% of that. But when you actually calculate the amount of pay that they get for their 50% leave or their 3/4 leave or whatever it is, then you're still using the same weekly average pay to do that calculation. Is it horrible? Yes, it is. So the best example I could find of getting my head around this when it first came out was my daughter. And I say it's the worst example, but you know, I think the worst is the figures at the bottom of this slide. So I'll introduce you to my daughter, Danya. She's 18, and yes, she has been on payroll for 4 years. She used to come and help me with various exhibitions and marketing and quite a lot of ad hoc work. A lot of stuff she did during lockdown, and then also working for me for the whole of this summer. In the past, whatever she's worked, I've given her 12.07% as her holiday. Now, we did pay that. I know we're a little bit naughty. We did pay that each month because her work was so ad hoc. It was really difficult to pay her for time that she was off. And in effect, she did so few hours a month that the time that she was being paid in each month, you could very easily say she was taking that time off. So she was being paid for the holiday as she took it. This summer, she's worked for 8 weeks. She's still on payroll. So she's still, and I've sent her some work to do today. So she's still on payroll and she's still being paid. But she worked for 8 weeks in the summer. And for those 8 weeks of work, this ruling says that I need to pay her 5.6 weeks of holiday pay. And because she was full-time, working 35 hours a week, if I were to calculate based on £10 an hour, under the 12.07%, she would have had holiday pay for £337.96. Under the new system, 35 hours a week at £10 an hour is £350. And I need to pay her 5.6 times £350, which comes in at £1,960. That is the discrepancy between the old ruling or the old method and the new method. And it's really interesting because when this was raised in the Supreme Court as part of the counter argument and all the rest of it, they actually said that there was very little difference between their ruling and the old way of calculating it. And I think that is the case if somebody is working sort of 32, 36, even 40 weeks of the year. But where you really have a huge discrepancy are people like Danya, who just come and work in the summer or just do a few hours, or people who are bank staff, or people who come in as Christmas seasonal workers. And that's where businesses really need to think very carefully about how they manage those going forward. And we will talk a little bit about that. Now, the one thing which brings down that new calculation is that reference period. So if Danya hadn't done any other work for the last 2 years, then that is what I would have to pay. But because she's done a bit of work here and a bit of work there and did quite a lot of work during lockdown, the average weekly pay does come down a bit, but nothing like that £337.96. So it is a huge, huge additional cost for businesses. And it means that businesses need to think very strategically about how they use extra resource and where they get that extra resource from. I'm just trying to figure out how to see your next question, Sarah. Hold on. Do we need to pay back amounts from this, or is this form a certain... Sit tight. Sit tight. So what we know, these rules must be followed immediately. Absolutely immediately. Employees do have the right to request back pay, and it's unclear for how long. Now, there's one train of thought which says they could go back 7 years, because that's kind of a figure that accountants use for tax purposes and that sort of thing. There's another train of thought that says actually this is over a 2-year period, so they could claim back pay over 2 years. Some say that actually, because the original case came out 2 years ago, it could be then. It's really, really unclear, really unclear. And that's where it's going to come down to a conversation between you and your staff. And you're going to need to work out what they would have got under the old system and what they would get under the new system. Look at what the difference is and make a decision. Okay. It is possible to reduce the amount that needs to be paid if you process people as starters and leavers every time they undertake a piece of work. So if I cancel Dania's contract now, take her off payroll, issue her with a P45, but she comes back at Christmas to do a couple of weeks' work for us, maybe to cover one of the team who's on annual leave, I'd need to offer her, I'd need to give her a new contract, need to get all her new starter paperwork signed up again. We'd need to get her back onto payroll. We'd need to pay her for the 2 weeks. We'd need to accrue holiday for those 2 weeks. And at the end of that period, I'd need to process her as a leaver again, taking her off payroll and just giving her the holiday that she's accrued for those weeks that she's worked. The same might be for, you know, people who pick fresh fruit, you know, the harvesters, and I don't think I've got anybody like that in certainly we don't in our client base. We've got a lot of accountants on here, so you may have fruit pickers or seasonal workers. If they're just brought in and put onto a fixed term contract for 3 months or 6 months and their holiday is paid for that period, then this is fine. But if you've got people that you bring in regularly and you just want to be able to phone them up and say, can you work tomorrow? And can you do 2 days? That's where this becomes really, really difficult. And please remember, employment law, you need to issue a new contract of employment on or before day 1 of each time someone starts work. So if you've issued them with a P45, you need a new employment contract to be issued on or before day 1 of when they're going to start again. You've also got Making Tax Digital, which means that you need to report everything in real time. Okay. We've tried to quantify how much time this is going to take. We think that on average, it could take 20 minutes per employee per leave period. Now, bearing in mind that someone could take 5.6 weeks of leave, they might take a 2-week holiday, but the rest of their 3.6 weeks may be taken as individual days. They may take long weekends. They may take 1 week off and then lots of long weekends. They may take a week and then 2 days and 3 days. And every time they take leave, you've got to redo these calculations. Okay, how they're going to keep track of it, I don't know. I do have a solution for how you're going to keep track, or you could keep track of it. What we don't know, the law says that employers have to give a minimum of 5.6 weeks to their full-time staff. If they give more than 5.6 weeks, if somebody gives 25 days plus 8 public holidays, that's 33 days. Okay. So the law at the moment and the ruling which has come out has not said that you can, it hasn't said either way whether or not you have to give that entitlement to the part-year staff or not. However, it's likely to be tested in the employment tribunal with case law, because a part-time employee or a part-year employee could bring a case for discrimination, saying they're being treated less fairly than their full-time counterparts. And under the part-time workers regulation, that is illegal. The other thing which makes this really complex is that potentially you could have a part-time employee who works 2 days a week throughout the whole year, and they could end up with less holiday time and pay than a part-year worker who works 30 weeks of the year but does more full-time work. And again, the Supreme Court looked at this and said, that's fine. They were happy with that discrimination. Now, that's the first time that we've seen as HR and as employment lawyers and as HR specialists, anyone turn around and say, apart from age discrimination around pensions and redundancy, but it's the first time that actually in day-to-day HR, we've seen someone say, yes, we know this is discriminatory and we're fine with it because it complies with the legislation. So we think that the 5.6 weeks will hold, regardless of whether you give more time off to your full-time staff, but we won't know until it's tested in case law. And again, I talked a little bit earlier, you know, how do you calculate if somebody wants 1 day off or 2 days off? How do you calculate their weekly pay? We've been given the formula, sorry, their holiday pay. We've been given the formula for average weekly pay, and we've made an assumption that it's either 1/5 or 1/6, you know, in order to calculate what a day is worth or how you calculate 2 days. So what do employers need to do next? Well, if you're an employer, you need to check your contracts of employment, your employee handbooks, your software. So if you're using software for holiday entitlements, how is it doing it? What is it doing? What's it prorating? How's it dealing with your 0 hours contracts? I haven't seen any of the software companies come out with a solution yet. I'm sure they're working on it. Decide how you're going to treat any back claims for incorrectly paid leave. That's back to Sarah's question. And as I said earlier, they will have the opportunity to claim. You need to come out with a policy. You need to work out by employee how much short they are. They might not be. They might have been overpaid. It's possible with this new formula. You may also have claims from leavers. And that's also something to be aware of. And make sure that you document it, communicate it, talk to your staff. You really, really need them on board. If you're an accountant or a payroll person, figure out which of your clients, if any, are impacted, and have a conversation about what they're going to do about it. Okay, what are they going to do? What contractual changes are needed, etc. You can't process anything until they've made an in-house decision, but they may need the information from you in order to enable that decision to be made. I've been talking to a PR specialist recently, and he is adamant that this is not on the horizon at the moment, and it needs to be. It hasn't had the traction that it should have had. And he also thinks that there are going to be, he called them ambulance chasers, but if you think back to the PPI claims where there were no win, no fee claims, he also thinks that that's going to start popping up. He's much more cynical than I am, but you know, where people were saying, well, if you've worked 0 hours, you're entitled to more holiday and we'll help you claim it for a percentage or a fee or whatever, I'm sure. But you need to have a plan for dealing with that if that arises. I've worked with a developer to create a toolkit, and I'm going to show you a video in a minute. It was the easiest way that I could think of demoing it. It calculates leave per employee. It calculates average salary per leave period, looking at the reference periods. It adds holidays back into the formula, and it calculates for you your rolling 52 to 104 weeks and takes the last 52 weeks in which there is pay. I tried to develop it. I'm quite nifty with spreadsheets. I do a lot with spreadsheets. I could not make this work on a spreadsheet. I've had to actually go out and ask somebody for help with this and develop it. There is a charge. After today, it will be $299 for accountancy practices, and I am allowing you to use that with your clients. And if a business wants it, then it's $249. It is not for resale. So if any accountants want to give it to their clients, then I would ask you please to come back and we can do some kind of deal. It is not for resale, but that does enable you to use it for multiple clients. Believe me, they probably don't want to touch it. It's so bleh. And if you order and pay by the end of tomorrow, then I've put £100 discount there for both of those purchases. Let's have a look. Hi, so this is the annual leave toolkit. I'm going to start off by introducing you to the 5 tabs along the bottom here. This admin tab you will only need once. You set the start date of week 1, and you want to go back at least 2 years from the time that you start using the system. You also put in your start date for your annual leave year. For some companies that's 1st of January, but for other companies that's going to be maybe the 1st of April or the 1st of September. And then also the number of hours per week. Once you've set the information on this tab, you can basically hide the tab. You don't need it again. This is just where you set up your system. This is a demo version. We've got a few sample employees in here, but the way in which you would add a new employee would be literally, let's put myself in, Donna, Obstfeld, start date, what was my start date? 1st of May, 2007. Let's just pick a default hourly rate of £15. I'm employee number 1, DO1, and we're going to save the employee. And I have now been added to that list, actually in alphabetical order. You can use that to bring up any of the employees on this main sheet when you're adding information. If you need to search for somebody, you can search by last name, you can search by first name, type their name in, and you can find their data if you've got more than you can easily see on the list here. we're going to use Margot as a sample for this data. So she started on the 1st of April. Her default hourly rate is £11, and that's her rate now. It wasn't when she started, as you'll see later. If we want to add salary, then we add it here. We would put in the date that she's been paid, how many hours she's worked that week. This is her new hourly rate, and then any other payments, and that might include any bonus, commission, or anything like that. And you would then press add salary. This is her salary record per year and her holiday record per year. So you can see how much she's taken, how much she's got left, and this is set at the 5.6 weeks. This then is just a record of the employees that you can use to have a look at their start dates, check that you've got everybody on the system, and this table is used as a lookup later on. This is where the payments go. So as you add information onto this summary table here, the information then appears on this spreadsheet here. And if I whiz you up to the top, you can see the employee's ID number, their name, the date that they were paid, whether it was holiday pay or not, and you'll see that there are some yeses down the bottom where holiday has been taken. The number of hours they've worked, what they've paid for it. So initially £10 for Margot, what they were paid. Here you can see additional payments. Okay, so this is bonuses, commissions, any other payments that were made to them, not expenses. Okay, this is just salary. Total payment. The system will work out what week it is, which year it is, which the start date is, and where it's pulling information from. Okay. In this instance here, we're then looking at payments made to employee number 6. You can see which weeks she's had pay, okay? And some of these weeks will be discounted for the purposes of calculating the 52 weeks, but all of the information is on there, and it will count back 52 weeks from where we are, or it will keep going back up to 104 weeks to when the reference period that we talked about earlier, okay? But you don't add anything to this table. This table is all driven from this summary here. So if somebody takes holiday, then the information is added here. And by pressing this add holiday pay button, it actually adds the information to the payment, and that's when it says yes in the previous column. And then you can see how much holiday has been taken, what's been paid, and holiday payments, etc. here. And you can key the information and look it up there. And then this is the holiday record for this particular employee, and you can change the employee reference there, and it will bring it up. So this is a demo version. This is what the toolkit looks like, but this one isn't fully activated. This gives you the sample information. So again, if we switch to Jo there, she's had different holiday entitlements. This is what she's got left. She's overtaken there. Let's see who else we've got in here. I don't know who else we have information for. There you can see salary record for Alice and also holiday record. Okay, so I hope that makes sense. It is only a demo, but it gives you an idea of the toolkit, the complexity. These numbers here are key because that's what enables the system to actually go back and calculate, okay, well, where do we have 52 weeks worth of pay data? What's our reference period, as I described earlier in the demo? Hope that all makes sense, but it gives you a flavour for the system. Okay, so hopefully we are back live again. And face the real, watching yourself do a demo there, but it was the best way that I could think of doing it yesterday. As again, just if anybody wants to order that toolkit, then please email me at donna@dohr.co.uk. Nearly coming to the end. I'm just answering a couple of questions in the Q&A. So Radhika, will it only affect will it also affect employees who have left the company? As I've said already, yes, we think it will, but we'll only really know if anybody tries to bring a claim, but you need to be prepared for that. Roxy, we don't pay holiday pay by an average. We don't pay holiday by an average. We pay is by the hour. So if someone takes one holiday day that would have worked 8 hours, then they are paid 8 times their hourly rate. Is this still correct going forward? Yes. It depends, as long as you're still giving them their 5.6 weeks. Very often pay by the hour is for people who don't work the same number of hours every day for the full year. So from that, it sounds like you might be overpaying them. I'm happy to have a conversation with you offline about that one. But yes, in theory, but you're monitoring to make sure that they get their 5.6 weeks, and then you would pay them. You need to look at what they would get under each method and make sure that it still works out, but we can have a look at that. Someone who is anonymous, I process payroll for staff that only work in non-term time, a holiday club. What would be the best way to deal with holiday pay for them? So in effect, they're not working full year, so they are absolutely covered by these rules. They are still entitled to 5.6 weeks of holiday, even if they work 2 weeks at Christmas, 2 weeks at Easter, and 6 weeks in the summer. What does that get us to? 6, 8, that's 10 weeks. They're still entitled to 5.6 weeks of pay. And you need to work out what their average weekly pay is. You know, if they're only ever working full weeks, that is going to get expensive. But that is absolutely a problem under the new legislation. And you're also, like I was with Dania, likely to see a huge increase in cost unless you start them and bring them on, make them starters and leavers every time you need them to cover a holiday period, which you've then got the admin that goes with it. So, but yes, they are absolutely under the new rules now. Okay, so I said I would touch on IR35. So last Friday, Kwasi Kwarteng announced that there were the changes from 2017, which applied to the public sector, and to 2021, which applied to the private sector, were going to be repealed from the 6th of April next year. This doesn't mean that IR35 is disappearing. IR35 was introduced sometime, I don't quite remember when, but in the few years leading up to the year 2000. And it was because there were lots of people setting themselves up as year 2000 contractors. It may even have been around longer than that, but that's certainly when I first became aware of it. It still applies. Okay, it's only the changes that were brought in 2017 and 2021 which are being repealed. The other thing to bear in mind, so basically what that means is that those changes made the employer liable, or the business, the end user, liable for determining status and for dealing with tax. You are still liable up until April 2023. So if you've got freelancers, contractors, Anybody like that, you still need to determine whether they are genuinely contractors, self-employed, etc., or whether they should be on payroll. The main thing that I want to say here is that tax legislation and employment legislation haven't been aligned. And just because somebody could be self-employed under tax legislation does not mean that they can be self-employed under employment legislation. And some of the big cases, or the biggest case in this area, is Pimlico Plumbers, a guy called Gary Smith, who was a plumber with Pimlico Plumbers. He was employed for 3 years, I think it was, earned £500,000. Might be the other way around, might have been 5 years and £300,000. Had a heart attack, went off sick, tried to claim sick leave, was told, no, you're not entitled because you're self-employed. He had a self-employed contract. BDO Stoy Hayward and some other really big accountants had all been involved in setting that up. And what they'd all completely ignored was the employment legislation. And that says, when's the work done? How's it done? Under whose direction is it done? And it looks at things like, you know, who's got the line management responsibility? Where does the liability, if the person providing the service is sued, then like for malpractice or something like that, who gets sued? I'm going to use the term employer or the individual, the business or the individual. And if it's the business, then that person needs to be an employee. They are not self-employed. If you're getting invoice number 1, 2, 3, 4, 5, and it's for the same amount every single week, they are an employee. If they are expected to attend work Monday to Friday, 9 to 5, and if they decide to take 5 weeks holiday and you won't permit it, then they're an employee. Okay, so I say, if it looks like a duck, waddles like a duck, and quacks like a duck, it is a duck, regardless of whether you call it a chicken, a hen, or a goose. So even if you have a contract which says you are self-employed, you are liable for your own taxes, we are not liable for this. If everything that you do in practice makes you look like an employee, including attending the work Christmas party, getting a bonus, you know, having an employee handbook, having to sign company policies, you are not self-employed, you are an employee. And regardless of what tax legislation says, employment legislation is still really, really important. Okay, so that's my little bit on IR35 for you. I hope you found today useful. Next week, if I get my act together, this book is coming out next week on Amazon. It is written, as you can see, the artwork has been beautifully designed by my designer. I did not do that. The book was held up because of the Supreme Court ruling. I'd written it all by beginning of July and then got wind that the ruling was coming out. So I held the book. And then we've spent quite a lot of time trying to get our heads around the implications of this. And I've had to rewrite that section of the book. This is all about annual leave. It will be available on Amazon from next week. I've publicly committed to it now, so I have to do it. But I will send out an email also when it's ready. Does anybody have any final questions before I wrap up? I'm giving you back 3 minutes of your day. Does anybody have any more questions? Anybody want to say anything? If anybody wants to put their hands up, they're welcome to do so, and I can unmute you if it's easier to talk rather than type. No, on that note, I will thank you all very, very much for joining me. If anybody would like to order the toolkit, then please do email me. Donna@dohr.co.uk. There are the fees again. And if you've got any queries, you know where to find us. Take care and thank you so much for joining us today.